Major support for Out to Lunch is provided by the law firm of Jones Walker, established in 1937 with over 375 attorneys in offices throughout the U.S., providing a comprehensive range of services to a local, national, and international client base. JonesWalker.com. And by Short & Associates, legal recruiters in Louisiana and Texas. And Orange Theory Fitness, delivering fitness results for a healthier world.
From Mansers on the Boulevard in Baton Rouge, we're out to lunch with editor of the Baton Rouge Business Report, Stephanie Riegel. It's business, Baton Rouge style.
Hi, I'm Stephanie Riegel. Welcome to Out to Lunch. Between the technology at our fingertips today, the access we have to information, and the rate of rapid change, there's never been a more exciting time to be an inventor, an innovator, or a creator. But those same factors that make it all so possible also open us up to complications and challenges that make us vulnerable to threats from competitors who may want to steal our great ideas. With me to discuss this today is Michael Leachman, an attorney with Jones Walker here in Baton Rouge, who specializes in patents, trademarks, and copyrights, all of which could be rolled together under the umbrella of protecting intellectual property rights. In his decade at Jones Walker, Michael has prepared and prosecuted patent applications covering a broad spectrum of inventions and technologies in the mechanical, chemical, biomedical, bioscience, and nanotechnology fields. He also has experience handling trademarks, trade secrets, and unfair competition litigation in federal and state courts. Michael actually got his undergraduate degree in biomedical engineering from Louisiana Tech, and perhaps might have invented some cool technology himself had something not lured him to law school. Michael, we're going to find out about what that was and what you're doing now, and it's a pleasure to have you here today on Out to Lunch.
Thanks for having me.
Joining me and Michael at the table is a man who knows a lot about patents and intellectual property. He is Jason Hugenroth, owner of Inventherm, an engineering R&D company that specializes in machine design and thermal fluid science for the medical, aerospace, defense, automotive, and energy industries. Inventherm is located at LSU's Innovation Park in the Louisiana Business and Technology Center and has state-of-the-art labs and prototyping machines that help users actually test their ideas, inventions, and technologies. Since Inventherm's founding, Jason has earned more than 50 patents in compressor and thermal system technology, including an oil-less air compressor for a medical respirator product, which is basically a type of portable oxygen concentrator. It's just an example of the really cool stuff that they're doing in Inventherm, and Jason, you're going to tell us a lot more about it. Thanks for being here today on Out to Lunch.
Great. Thanks, Stephanie. It's great to be here.
Well, Michael, I'm going to start with you. When we talk about intellectual property rights, it's a broad category. You kind of do it all. Tell us real briefly, what is intellectual property, and kind of where would you want a copyright versus a trademark versus a patent or a license? How does it all fit together?
So you're correct, intellectual property is a broad term. It's an umbrella term that captures a bunch of different types of property rights that the law provides. The four main common areas of intellectual property are patents, trademarks, copyrights, and trade secrets. So if you're going to try to compartmentalize these four different types, when you think inventions, think patents. When you think some sort of artistic creation, think copyright.
Okay.
When you think brand, think that means it's going to be trademark protection. And a trade secret would be something like the Coca-Cola formula, something that no one else knows about, but it has value.
Interesting. Okay, that's a beautiful breakdown. So what are you doing the most of in your practice, and where are you seeing the most activity in this market?
So I'd say that the breakdown at Jones Walker across all of our intellectual property attorneys is probably about a 50-50 split between patents and trademark work. Mm-hmm. And that's also split about a 50-50 ratio with litigation, as well as doing transactional work where we're helping clients actually get these rights. But we also, help clients on the back end where we're either defending them from a lawsuit from a competitor, or we're being the aggressor and we're representing our clients enforcing their IP rights.
That is so interesting. Which one do you like more, the litigation side or the front end?
I probably lean more on the litigation side, just because I think it fits my personality a little bit better. But I do both, and there's certainly some attorneys that would give you a different answer and say they prefer more of the transactional work, it's less contentious.
Well, I don't know if you've run across Jason in your work, but Jason, Inventherm has a fascinating business model because you're working with intellectual property all the time. You help engineers and other inventors bring their technologies and inventions and ideas to help them become a reality. Is that right?
That's right, yeah. And it can be anything from an individual, a startup company, or we've worked with, multinational, multi-billion-dollar companies on everything from a new product to just improving an existing product.
So multi-billion-dollar companies have come to you and said, basically, help us develop or test this idea?
Oh, yes. Yeah, definitely. We worked with PepsiCo at one point on a particular type of cooling system for a particular market segment. It also involved another company that we were working with. The oxygen concentrator compressor that we developed was for a little bit smaller company, but maybe $50-100 million kind of sales company. But then during the project, they were bought by a multinational company, and we continued the work. So, and we've had just individuals that come to us with something they got a patent on. And
cool.
Yeah.
And so you all specialize though in like compressor and thermal system technology.
We have done. I mean, we're really a turnkey facility in that we'll take something in our kind of wide area of expertise and take it all the way, including the electronics and packaging and dealing with manufacturers. But we've had a tendency to do a lot of work, refrigeration and compressor related, some power generation stuff as well.
And you've worked with NASA? Is that
yes, we've had
also?
some funding from NASA for a small power generation technology, and so what happens on certain flyby aircraft or rovers and whatnot, they may not be able to use solar, get enough energy from solar photovoltaics. So currently they use a radioactive heat source for kind of various types of engine technologies. And the current one that's kind of used is very reliable but quite inefficient. And so we've had a little bit of funding for a different power generation technology that's much more efficient. But it's still in early stages of development.
So, I mean, I want to say, what are you doing in the business incubator at LSU? How did you get here?
We we're a small company, and the incubator works for us. I'm from Louisiana, Alexandria originally, and I went to LSU, did my undergrad and master's there, and then moved out of state for about 10 years. Worked for a company in Arkansas, then went back to school at Purdue to get my doctoral degree in mechanical engineering. And after that, my wife and I just decided we wanted to get back closer to where our family was. We had a couple of kids by that time, and so we chose Baton Rouge as being a good place to start a business.
And is it panning out? It sounds.
It has.
Like
We've been in business for 12 years now. Like I say, we're still a small company, but we've been successful and generated some successful products.
That's great. Now, Michael, are most of your clients in this field local? Or are they regional? Are they national? I know Jones Walker does work all over, but
I'd say it depends on the type of intellectual property work. So litigation-wise, I'd say the work is more national, whereas the transactional work is more regional. And so I would say that the Gulf Coast footprint pretty much defines kind of our primary market for intellectual property.
So what kind of intellectual property do you see?
So because we're in Louisiana, I would say a majority of the work that we do is somehow related to the oil and gas industry. It's certainly not exclusively what we do, but that happens to be the number one industry that we have here in South Louisiana as well as in Houston. And so those types of technologies can range from tools that are used in downhole drilling operations to different chemicals that are used in drilling operations and things of that nature would be some of the examples that come immediately to mind.
And are a lot of these inventions or ideas developed in the field by engineers that are just out there working it and have recognized the need for it, or is it coming out of the university?
So, I mean, certainly universities that have research going on will have technology that becomes patentable technology that they seek to patent. But I'd say a predominant amount of work that we do is in private industry, and most of those patentable inventions come from problems that they encounter in their normal business operations. and the invention lies in the solution of that problem. And so that's ultimately any patent that's going to be valuable, you want it to be solving a problem. And so that's usually the most fruitful way to try to identify something that's worth patenting to begin with.
So interesting. And Michael, you've been involved in 50 patents through Inventherm. Does Inventherm take an ownership stake or some sort of equity position in these companies that it helps develop, or do you just get a fee for helping them find their way?
It depends on the relationship. Certainly companies tend to want to keep their IP, right? Their intellectual property, but it can depend when we get into, say, the compressor area where we've done so much work. There's going to be some significant restrictions on what we'll give up, and we've invested tens of thousands of hours, millions of dollars in developing technology, and if a company comes in and wants to pay us to modify or do some additional technology, we're not going to just turn all that over. We've had projects where we start out just doing some consulting, and we'll carve out like a field of use, say anything in this field that we're working for, that's your property, and we'll do some work for a while, and it's ongoing, and they're happy with what we're doing, and then we may get into we're gonna maybe give you a little bit of equity in this, so we can decrease our their burn rate for this development. So we have those kind of opportunities that come up as well.
Jason, do you usually try to work out on the front end the arrangement that's going to take place between you and your customers?
Yeah, absolutely. That happens before we do. We may do some basic analysis, and we can kind of completely stay away from the IP stuff if we're just doing some, kind of technical analysis. But if we're getting into the development part, we're gonna right away get into how we handle the IP. And we've generally we've always been able to work out mutually agreeable situation once they understand our side of what's happening. We have to be real careful that we don't tie our hands for a future project. While at the same time they need to protect their investment.
Yeah, so Stephanie, that's the issue I see mostly with our clients when they are having to outsource some of the design work on patentable inventions, is not getting agreements in writing up front, and sometimes ending up with a situation where there's joint ownership of the technology because the engineering firm that assists them with developing the prototype might make some suggestions that improve the original design, and therefore now the engineering firm has part ownership because they have some inventors on the patent application itself, and that can create a very messy situation that's very hard to fix, particularly when a lot of money becomes involved.
That hadn't happened with y'all, Jason?
No, I've never had that issue. Like I said, I'll bring it up. If they don't bring it up, I'll bring it up right away. We'll make sure we're all settled, and better to avoid those type of disagreements. And we want to have a good working relationship with our clients. We're not out to we're being paid for our work, and like I say, we need to make sure we don't get our hands tied, or if it's, again, it gets in these areas where we've just done a tremendous amount of work, we're just going to be very careful about what we give up, but we're going to let them know.
Do you all have any of your own technology that you've invented and patented and are selling or marketing or licensing?
We have stuff we're working on. The NASA work with the small power generation technology is one that's Inventherms technology. We are working on another one we're very excited about. That's a commercial end product. Unfortunately, I can't talk too much about it on the air yet, but we're kind of at that point where we're ready to get. We've built some prototypes and we're ready to get our investors lined up. So we do a little bit of both. It's a two-pronged. We're open for business for consulting work. At the same time, we're trying to develop and spin off our own technologies.
Power generation, you mentioned. What exactly are you all doing or helping them do in the power generation?
So it's small scale stuff, and the NASA work is related to use radioactive heat sources to generate power for spacecraft, rovers, and whatnot, deep space vehicles.
Wow.
That would be, they have a very long development cycle, many years away, but it has applications for, people are familiar with, electric cars are much more common now, but the real problem is a liquid fuel like gasoline has about 100 times the energy density of a battery. And so it's really hard just to get the range and whatnot. So if you can produce make a small engine technology that can use a liquid fuel, there's a lot of portable electrical devices that would not only be able to last longer, but would be in some cases become viable, where they're just not some types of exoskeletons and personal cooling systems that the military is interested in. They're not really viable because they don't have a good power source at that small scale, and that's kind of where we're targeting with.
So are you like on the cusp of inventing the holy grail of power generation?
Well, it's a long. We're still a little bit. We've done some proof of concept work. We've had some funding from NASA and also National Science Foundation. Technically, it's solid, but the details are always a challenge, and it's a lot of work to get that done.
You're listening to Out to Lunch. I'm Stephanie Riegel. I'm talking to Jason Hugenroth of Inventherm and Michael Leachman of Jones Walker. We'll be right back after this very short break. You're listening to Out to Lunch. I'm Stephanie Riegel. I'm talking to Jason Hugenroth of Inventherm and Michael Leachman of Jones Walker. This stuff gets really technical. Obviously, Michael, do you have to understand it to be able to effectively, deal in this arena, or is that where maybe your engineering background comes in handy?
Well, so to be a patent attorney, you have to have an engineering background or some hard science background.
Really?
And that's part of, you have to take a separate bar exam even to be a patent attorney. And part of the prerequisite for sitting for that bar exam is to have that technology background. However, patent attorneys are never supposed to be the experts in the technology. The experts are always the inventors. Our job is mainly to make sure that we have the educational background so that we can be taught and become an expert for about a 2-week period of drafting the application, and then we set it down and move on to something else that we have to become experts in. And so it's kind of being a chameleon.
It's a real challenge because the engineers aren't experts on the IP, and it's a little bit the more both can learn about what the other one's doing, the better, more effective patent you're going to end up with. It really helps for the engineer to understand what a patent is for and what it really does.
Yeah, so I think what Jason is saying is that the patent attorney's job is to be an expert on patent law. The inventor's job is to be an expert on their invention, and ideally, you both are exchanging information and both really understanding what the process is from a legal standpoint and understanding the technology at a very granular level, so you make sure that you get everything you need to in your application.
So let's say you come up with a really great invention, some device. What do you need to do to protect it from, intellectual theft and then license it and hopefully make money from it? What are the steps? And maybe y'all approach it from different ways. But
well, what we would start with is we'll put together a document, and I've done enough now that I know what to do to properly explain to the patent attorney what we have and what we're trying to protect. And I'll go as far as we'll do the preliminary prior art search, which is actually looking at what's out there already, especially in the existing patent literature, so we can kind of get an idea of if what we have is patentable, and then we'll turn that over to the attorney, and they'll start, of course, asking questions and advising us, and then that's where y'all take over, Michael.
Yeah, so one thing that's important to understand is that just because you file a patent application doesn't mean you're actually going to get a patent. The patent office has an army of patent examiners whose jobs are to be gatekeepers and not to let every single application grow into a patent. And they're going to do a search to see what else already is out there, whether it's in patent literature or in New England Journal of Medicine. They're going to search to try to find any written disclosures that show that the applied for invention is not new, or even if it's new, that it's obvious, meaning it's such a small improvement over what already exists that you shouldn't get patent protection. So what Jason was explaining is that with his process, they usually try to replicate what the patent office is going to do themselves before they even contact a patent attorney. The other option would be to contact a patent attorney and have the patent attorney help guide you through that research on the front end before you expend the money to do a full patent application.
Okay. Have y'all ever seen it where, for instance, like two people are working on the same thing at the same time? I mean, knowing how things develop and evolve, somebody's hears of it, and what happens then?
Yeah, I don't know if I've seen it where somebody's actually working on the same time, but you certainly almost always find some kind of relative prior art. And so you just start to, that doesn't mean you abandon what you're doing. You're still looking for what's new about what you have. You can't maybe claim as, you'd like to claim everything under the sun in your patent, but you have to narrow it down, and that just begins that process. But I think people are pretty secretive, and they're keeping their IP under wraps, and you will see and the applications eventually get published, and that's all online. So you will look through that as well to see what's out there.
Well, it happened often enough that before the Patent Act was changed here recently in 2012, there was actually a proceeding at the patent office when you had two people apply for the same invention. It was called an interference proceeding. So,
Really?
So while I haven't seen it personally in my practice, it certainly happened enough that there was an entire proceeding that the patent office had to try to figure out who was the first inventor. Now we've shifted to a first to file system. So historically, the United States always was a first to invent patent system. The rest of the world had been a first to file system for quite some time, and with the America Invents Act that was passed under the Obama administration, we're now a first to file system. So you're not seeing interference proceedings anymore. It now becomes who gets to the patent office first is going to be the winner.
Huh. And I guess the process is lengthy to get your patent license approved, application approved?
Yeah, a couple of years generally from my
Couple of
experience.
years.
Yeah.
Yeah, there's a backlog of about 600,000 to 700,000 patent applications sitting up,
600,000 to 700,000.
sitting in Alexandria, Virginia, waiting for a patent examiner to have time to take a look at it. So it can sometimes take up to 2 years before the patent office even looks at your application.
And in the meantime, you're vulnerable, I suppose. But you're wanting to develop your product and bring it to market, and right?
Yeah, there's some risk there. So you're gonna rely a lot on the again, we'll do our own background search, but we'll have a professional prior art search done. So we're trying to see what's out there. But you're exposed if somebody, I believe Michael's at 18 months applications are published after a non-provisional is filed.
They're published after 18 months unless you ask for it not to be published.
Yeah, so there can be stuff out there that you're just not seeing. So there's certainly some risk.
That's what patent pending means, right?
Yep.
I
So-
get-
Right.
And so from an offensive standpoint, the law does provide for this concept known as provisional rights. So even if you're patent pending and you see someone that's infringing your pending application, you can try to put them on notice of your application. And if in fact, your patent ultimately issues, you can get damages dating back to when they were put on notice. So even though you didn't have a patent, you couldn't sue them at the time, you put them on notice, you still potentially get some damages for the infringing activity that happened during this patent pending status.
Okay.
In practice, it's very hard for that to actually work for a variety of reasons. It's probably a little too much of a deep dive. But what I think Jason was getting at was the risk of when you file an application, you don't have that guarantee that you're actually going to get a patent. And the fact that it takes so long to get that answer from the patent office, it can slow down efforts to get funding and things of that nature, because no one knows for sure what's going to happen with the process. And so there's a little bit of risk that comes into play. And I tell all of my clients that you've got to look at the patent process as a certain level of risk. There's no guarantees here. Even if you do the perfect patentability study at the front end, you still can be surprised.
Jason, have y'all worked with any companies that have really hit it big, thanks to the technology that they developed through you or with your help?
I would say a product we're working on right now for a company, for a startup, is going to be probably the biggest thing yet that we've worked on as far as.
Can you give us a hint? Is what they do?
It's a consumer appliance related to ice cream.
Oh. I love it.
It's very novel. Came to us with an idea, and we first kind of just vetted, see if it was possible, and we're several prototypes in. It's going very well. So it's something I think people are going to be seeing here in just maybe a couple of years.
Okay. Well, thank you for sharing that. I know we've been talking a lot about patents and inventions on the technology side, but I just wanted to ask you, Michael, for a minute about more creative products, and especially with the internet today. You write a song or a poem or a book. How do you protect that? And plagiarism, of course, is such a huge thing. I mean, I used to work in food and with recipes even. I mean, that was just a nightmare, because how do you really protect a recipe?
Yeah, recipes are very difficult just because it's hard to identify what's yours versus what is independent creation of someone else. And so what we're talking about typically when we're talking about any sort of artistic creation, we're dealing with copyright rights now. And whereas a patent protects you against reverse engineering and it protects you against independent creation, none of those are defenses to patent infringement. Copyright, all of those defenses are in play, meaning if you paint the prettiest picture you've ever seen, if someone across town paints the same picture of the same tree, for instance, if they did it without looking at your painting and they end up being substantially similar, copyright law says that's perfectly fine. And so copyright law is mainly trying to prevent, like you kind of hinted at, which is plagiarism or stealing or copying. That's where the word copyright comes in. What ways to protect yourself? Certainly, seeking registrations of your copyrights. It allows you to have a much quicker avenue to recourse in court by having a copyright registration in hand already. The other things is just being smart. If you're a photographer, if you're putting photographs up on social media, put watermarks, put things that make it more difficult for people to take your property and reproduce it. I mean, we see with the internet now, it's so easy to reproduce photos.
Sure. And just when you want to snag something to put in a PowerPoint presentation, for instance, right? I mean, you just want to grab an image and...
Oh, yes. I mean,
things like that.
I have to be really careful because I figure that if someone ever gets to sue an intellectual property attorney for copyright infringement, that'd probably make some news. So, something we have to deal with at our firm as well when we're doing presentations is making sure that, if we're using some sort of stock images, that we have licenses to it.
Interesting.
Is your litigation mostly on the patent arena, or does it get in the copyright as well? Or?
We've done some copyright litigation. I had a really interesting case several years ago that involved several rap labels where it was a really big copyright infringement mess. It involved making bootleg CDs in prison, in the prison system here in Louisiana. And so it was a really messy case.
I bet that was...
Yeah, because some of the owners of the record label were actually in the prison, so there was a question of whether or not they were kind of fueling this litigation to start with. But that case was definitely it was certainly.
Did you win
case.
that one? Did your client win?
Yes, there's a huge spectrum of winning and losing in litigation. Sometimes winning doesn't mean a big pot of money at the end, but that was certainly there was a resolution that our client, who I won't name, was happy with.
Well, Jason Hugenroth and Michael Leachman, you are both on the cutting edge of bringing cool technologies and inventions and ideas to market here. And Baton Rouge is fortunate to have you helping others get their intellectual property out there. So I wish we had more time to continue this very interesting discussion. But thank you all so much for being here today.
Great. Thanks, Stephanie, for having me.
Thank you.
My guests today on Out to Lunch have been Michael Leachman of Jones Walker and Jason Hugenroth of Inventherm. You can find out more about Jones Walker and Inventherm by going to the links on our website, itsbatonrouge.la. The producer of our show is Grant Morris. Our technical producer is Eric Merle. Our associate producer is Peter Raschuti. And our Baton Rouge business consultants are Charlie D'Agostino, Ann Edelman, and Dave Winwood. If you want to know what we all look like, you can find photos from this show on our website, itsbatonrouge.la, and on our It's Baton Rouge Facebook page. These photos were taken by Carrie Hosford, and you can find more of Carrie's photos at carriehosford.com. You can hear this show and past episodes of Out to Lunch wherever you get podcasts and at itsbatonrouge.la. Out to Lunch is a production of INO Broadcasting for itsbatonrouge.la and WRKF 89.3 FM. I'm Stephanie Riegel. Thanks for joining me. I look forward to meeting you again next week around the table here at Mansur's for more business Baton Rouge style on Out to Lunch.
Out to Lunch Baton Rouge is recorded live over lunch at Mansur's on the Boulevard in Baton Rouge. Mansur's is open for lunch daily 11 to 2, for dinner nightly, and for brunch on Saturdays and Sundays. Mitchell Foreman wrote and performs all the music on Out to Lunch. You can hear Mitchell's music anywhere great jazz is sold or streamed, and at mitchellforeman.com. Major support for Out to Lunch is provided by the law firm of Jones Walker, established in 1937 with over 375 attorneys in offices throughout the U.S., providing a comprehensive range of services to a local, national, and international client base. JonesWalker.com. And by the Alliance Safety Council, delivering instructor-led on-site computer lab and online training through more than 100 authorized training providers in 31 states and 2 countries. Headquartered in Baton Rouge, Alliance is focused on the future of learning technology and training process innovation for business and industry, for safety and other corporate training needs. More information is at alliancesafetycouncil.org. And by Shorten Associates, legal recruiters in Louisiana and Texas. And Orange Theory Fitness, delivering fitness results for a healthier world.